Here's a great question from Quora. When we register a trademark for one type of goods or services, does this automatically give us exclusive rights to use that trademark for all goods and services? My name is Andrei Mincov. I'm the founder of Trademark Factory. And before I answer this question, I suggest that you subscribe to this channel because I answer questions like this all the time. I've answered hundreds of questions, and if you're interested in branding, trademarks, intellectual property, entrepreneurship, if you subscribe, you'll be notified whenever I answer a question like this one in the future. And if you've got a question that you want me to answer, make sure you post a comment below and I'll shoot a video to answer your question. Now, to go back to this question, when we register a trademark for one type of goods and services, does it give them exclusive right to use that trademark for all other goods and services? Well, here's my answer to this question. Well, the answer is no. When you register your trademark for one type of goods and services, you can use the name for other goods and services unless somebody else owns that trademark for those other goods and services. Because a trademark is not a requirement before you can use that brand for any products and services. So for example, let's say we trademark the brand Trademark Factory, right? My brand, and it's registered in Class 45 for intellectual property services, legal services. That's the core service that we provide. And then when I decided to print Trademark Factory t-shirts that we use for promotional purposes, that we send out to our clients, that we send out to our team members, right? I use the brand Trademark Factory on them. That's a totally different class. That would be Class 25. But I didn't require the trademark to be in Class 25 before I could make, print, sell, and give away t-shirts that say Trademark Factory. But even though I can use the brand Trademark Factory for products and services that I didn't register my trademark for, so in Class 25 in this case, it doesn't mean that I have an exclusive right to the name Trademark Factory in Class 25. Now, there's a good chance that I'd be able to use my registration in Class 45 to go after someone if they decided to sell t-shirts with the name Trademark Factory or with the logo of Trademark Factory, simply because the name so clearly pinpoints to my business. But it doesn't mean that I have an exclusive right unless I get a trademark in that class. So if you are having multiple goods and services that your business offers, make sure that you file your trademark in all of those categories, all of those classes, for all of those goods and services. That's the only way to get the exclusive right to the use of that name or that logo or that tagline in connection with those goods and services. So otherwise, why would they have why would they have multiple classes? Why would they have government fees that go for each of the classes, right? If you could file in one class, if you could register in one class and automatically get protection for everything else, there would not have been a need for them to have you specify the classes and pay for each class in government fees, right? So that's kind of obvious. And so I think, like I said, there's two answers to this. Yes, you can use the mark regardless of whether you've got a trademark registration there, but your ability to enforce it is very limited, and certainly it's not an asset for those other goods and services that you haven't trademarked your brand for. I hope this answers your question. Make sure you like this video, make sure you subscribe, make sure you post a comment below with your feedback or with a question if you have one. And until then, I will see you in the next video.